The world is witnessing a wave of data protection and privacy laws. Is Brazil an exception, or does it have a comprehensive legislation such as the European regulation? How does this impact your business in Brazil? My name is Rafael Vaz and this is the Lobo Vaz Legal Channel. The cross-border flow of personal data impacts people's privacy and the security of companies' information. This is a critical topic, especially in a data-driven economy that suffers from an escalation of sophisticated cyber attacks. With technology advancement such as artificial intelligence, the Internet of Things, blockchain, cloud service, among others, several national and regional personal data protection strategies have emerged. We are now facing a fragmented and complex global digital governance structure. We verify for our clients who run business globally that legal uncertainty and the multiplicity of regulatory frameworks have an impact on the operation, especially concerning international data transfers and constant expenses with compliance. To our customers operating in the European Union, it is worth mentioning that the European regulatory model for data protection is in fact the most influential in the world. You see, since the Convention 108 through the Directive 95/46 and the current General Data Protection Regulation, the GDPR, the European model ignited the discussion worldwide. Since 2010, Latin American countries have implemented new data protection laws or made reforms to adapt to the strict standards of the European Union. To our partners operating in China, we have the recent Personal Information Protection Law that bears resemblance to the GDPR. Meanwhile, to our clients in Quebec, Bill 64 is on the way, which will modernize the existing data protection frameworks to follow in the footsteps of the European Union model. We can also mention the complex United States scenario. There's an effort there to create a comprehensive federal law for personal data protection. The California Consumer Privacy Act and its amendment by the California Privacy Rights Act are regulation more in sync with the GDPR. Apart from that, countries such as Argentina, Israel, Japan are recognized as suitable countries by the European Commission, which allows free flow of personal data. And what about Brazil? Well, despite not yet having an adequacy decision by the European Commission, Brazil currently has a legislation that displays several points of convergence with the GDPR. We are talking about the Brazilian General Personal Data Protection Law, known as LGPD. Those who are already familiar with the European Union framework, compliance will be easier, but, and this is important, compliance with the GDPR will not guarantee a prompt compliance with the LGPD, the Brazilian law. Both regulations have some important difference regarding lawfulness of processing, rights of the data subject, the need to appoint a representative and a DPO, the obligation of a contract to recruit a processor, international transfers and others. Therefore, the LGPD affects all entities that share business with Brazil or that, for an example, intend to import personal data from Brazil. Thus, it is important to have a specialized legal counsel that can offer you and your company knowledge and experience at international level. Thank you so much and see you soon.